Welcome back. I'm Elizabeth Khalil, and I'm joined by Glenn Gimbel. In this segment, we'll be discussing record retention and required policies and procedures under the LO Comp Rule. But before we begin our discussion of these provisions, let's briefly review a few other aspects of the rule relating to loan originator compensation. First, let's address the permissibility of pricing concessions under the LO Comp Rule. Under pre-existing Regulation Z commentary, a creditor and loan originator could not agree to set the loan originator's compensation at a certain level and then subsequently lower it in selective cases, such as where the consumer is offered a reduced rate to meet a quote from another creditor. The LO Comp Rule now provides a limited exception to this prohibition. A loan originator may reduce compensation to defray the cost, in whole or in part, of an unforeseen settlement cost not disclosed to the consumer under RESPA, or an unforeseen increase in an actual settlement cost over an estimated settlement cost disclosed to the consumer. An increase is unforeseen if the increase occurs even though the estimate provided to the consumer is consistent with the best information reasonably available to the disclosing person. This exception under the LO Comp Rule should provide relief to banks and other creditors where such disclosure discrepancies cannot, in good faith, be avoided. Next, let's briefly discuss the prohibition against dual compensation. The LO Comp Rule restricts loan originators from receiving compensation directly from a consumer and from other persons. Specifically, the rule provides that where a loan originator receives compensation directly from a consumer in connection with a covered transaction, no loan originator can receive compensation from another person directly or indirectly in connection with the same transaction. And no person who knows or has reason to know of the consumer paid compensation to the loan originator can pay any compensation to a loan originator in connection with the transaction. However, the LO Comp Rule provides an important exception to the prohibition against dual compensation, one that should prove useful to community banks when operating as a loan originator organization. Prior to the LO Comp Rule, a loan originator organization could not share origination fees received from the consumer with its individual loan originators without violating the prohibition against dual compensation. This compensation restriction proved difficult for community banks and other institutions that often brokered mortgage loans to other creditors, but who wanted to pay their individual loan originators a commission on these transactions. The LO Comp Rule addresses this limitation by providing that if a loan originator organization receives compensation directly from a consumer in connection with the transaction, the loan originator organization may pay compensation to an individual loan originator in connection with this same transaction, and the individual loan originator may receive it, without violating the prohibition against dual compensation. This exception allows a mortgage broker, such as a community bank that does not finance a particular mortgage loan using its own funds, to nevertheless pay its loan originator a commission on such transaction. Remember, however, that the commission paid to the individual loan originator by the loan originator organization still cannot be based on any other loan term or a proxy for a term of the loan. As a reminder, loan amount is not a term of a loan under the LO Comp Rule.
The LO Comp Rule also clarifies Regulation Z's prohibition on steering. As described earlier, the LO Comp Rule provides that a loan originator cannot direct or steer a consumer to consummate a transaction based on the fact that the originator will receive greater compensation from the creditor unless the consummated transaction is in the consumer's interest. A loan originator complies with the prohibition if he or she presents to the consumer specific loan options as required by the rule, one of which is the loan with the lowest dollar amount for discount points, origination points, or origination fees for which the loan originator has a good faith belief that the consumer likely qualifies. The LO Comp Rule, however, makes one important clarification. Where two or more of these loans have the same total dollar amount of discount points, origination points, or origination fees, the loan originator must present the loan with the lowest interest rate that also has the lowest total dollar amount of discount points, origination points, or origination fees, and for which the loan originator has a good faith belief that the consumer qualifies. As the rules on steering have not changed dramatically from previous regulation, this presentation doesn't delve into detail on this aspect of the LO Comp rule. However, before we move off of this topic, we wish to clear up what appears to be some common misunderstanding related to the prohibition against steering and the LO Comp restrictions. The steering prohibition and the prohibition on paying compensation based on a term or proxy of a transaction are two separate provisions that require independent analysis. The steering provision, as we just reviewed, prohibits a loan originator from directing a consumer to a transaction that results in higher compensation to the loan originator unless the transaction is in the consumer's interest. Recall that the compensation restrictions prohibit loan originator compensation based on a term of a transaction or a proxy for a term. Be sure to address this distinction in your policies and procedures and overall compliance management program to ensure compliance with both of these prohibitions.
Now let's focus on two other areas of the LO Comp rule: record retention and required policies and procedures. First, let's discuss the LO Comp rule's record retention requirements. A creditor must maintain records sufficient to evidence all compensation it pays to a loan originator, and a copy of the compensation agreement that governs those payments. A loan originator organization must maintain records sufficient to evidence all compensation it receives from a creditor, a consumer, or another person, and that it pays to its individual loan originators, and the compensation agreements that govern those receipts or payments. The records evidencing receipts or payments must be retained for a period of 3 years from the date of the receipts or payments. The official interpretation to the LO Comp rule explains that records are sufficient to evidence payment and receipt of compensation if they demonstrate the following facts: the nature and amount of the compensation, that the compensation was paid and received and by whom, and when the payment and receipt of the compensation occurred. However, what constitutes records sufficient to evidence payment and receipt of compensation necessarily will vary and will depend on the facts and circumstances of each case. Please refer to the LO Comp rule at 1026.25 C2 for further guidance. It's important to note that these record retention requirements do not apply to individual loan originators, only loan originator organizations and creditors. Although consumers may bring actions against any loan originator, which may include an individual loan originator, the CFPB stated that applying the record retention requirements to individual loan originators was unnecessary and duplicative in light of the records required to be maintained by creditors or loan originator organizations as applicable. The LO Comp rule implements the requirements of the Dodd-Frank Act that depository institutions establish and maintain written policies and procedures reasonably designed to ensure and monitor compliance with the following provisions: restrictions on payments to loan originators, prohibitions on steering, loan originator qualification requirements, and loan originator identifier requirements. Depository institutions should establish such policies and procedures to ensure and monitor compliance with these requirements, not only for the institution, but also for employees, subsidiaries, and subsidiaries' employees. Lastly, the LO Comp rule provides that the required policies and procedures must be appropriate to the nature, size, complexity, and scope of the mortgage credit activities of the depository institution and its subsidiaries.